So sorry for this last.
There was one machine that didn't have any water, and it was like... Okay, so I think we can get started. First of all, I'm so thrilled that the Center for Business Law second speaker for the year is Dr. Atusa Alabi. Let me tell you a little bit about her. In addition to being a former student of mine, I'm so thrilled she's back, Dr. Alabi is Senior IP and General Counsel at Alpha Micron, Inc., a leading liquid crystal technology research and development company in Kent, Ohio. Her primary responsibility is to create and implement a strategic plan for the protection of the company's patents, trademarks, and trade secrets. As General Counsel, she's also tasked with the protection and enforcement of Alpha Micron's intellectual property. And as part of these responsibilities, she's involved in working with internal and external groups for the creation of relevant worldwide patent and trademark portfolios. She has a very interesting background. She started her legal career as an associate with Jones Day, Cleveland, splitting her time between patent prosecution and litigation. She's then joined the intellectual property department at Calfee, Holter, and Griswold, primarily focusing on biotechnology and biomedical patent preparation and prosecution before becoming in-house at Alpha Micron. But I did not know when I had her as a student that she started her professional career as an oral surgeon in the United Kingdom, holding both a Bachelor of Dental Science and Master of Science degrees. Then she continued her education, conducting biomedical research in both the UK and the US, and has a Master of Philosophy in Neuroscience from the University College London. She received her JD with honors, of course, at Case Western. So you got the flyer. She's going to talk about the many misconceptions around what protection of intellectual property rights confer and whether to pursue them or not. She's going to dive into the what, why, and when patents make sense, busting myths surrounding the acquisition and enforcement of intellectual property, as well as formulating agreements with IP provisions, including NDAs, licenses, and joint development agreements, common pitfalls to avoid, and how to ultimately formulate IP decisions and strategies that make economic and business sense. So with that, I turn the program over to Dr. Alabi.
Thank you very much, Professor Kistreski. Thank you very much to the Case Western Reserve Law School for asking me to come and speak. Obviously, I love this place. I was a student here. I graduated in 2003, and I'm really thrilled to be asked to come back and speak. And listening to that introduction, I realized that everything that's in that little paragraph is probably a course. And I'm not sure if I'm going to stick to the script and follow and be able to do all of that in 1 hour, but I will do what I can based on the experiences that I've had actually in the industry and at Alpha Micron. I do want to leave some time at the end to ask questions, but please, if you would like to ask questions throughout, go right ahead. there's no format and we can just be free-flowing here. Here's a little bit of what will be covered. I'd like to talk about the value of IP rights generally, and as they apply in a business situation. Then I want to go back to patent rights basics. I'm not going to talk a lot about trademarks because that's not my strong point, and I'm much more of a patent person, so I do apologize for anybody who's here for trademarks, but you can ask me questions, that's fine. Then, of course, most of this is going to really be what is the interaction and the intersection of IP and business in terms of strategizing. Some talks about IP acquisition enforcement, and really, at the end of the day, the aim is to formulate IP decision and strategies that make sense for the business. So, and this is here, but if I walk around and talk, can you hear me? Okay, yes. Because I don't want to start recording. Good, great. So the value of IP rights, this is the general idea that that everybody gets about why do we even have IP rights. There's all these policies that are going to drive forward innovation, there are all these policies that drive forward business, and this is why IP rights are all there as a whole, and this is all great. And this is what you learn in law school, and then you scratch your head when you go to work and you say, what does that all mean? What am I supposed to do when I'm actually in a situation where everybody's running, and what are we running towards? Is it really, are we running towards the patent? I don't know if you can see up there, but that's actually a claim hamburger, and how it would look like in a patent situation. So it's really a daunting prospect to try and synthesize everything that you've learned and put it into a strategy. So this is hopefully what I'd like to talk to you about today. So I can talk to you about my experience at the company, and I'd like to therefore give you a little bit of history about Alpha Micron. Alpha Micron is a technology company, small technology company at the moment, and for a very long time we've had like 30 people. It's based in Kent. It started about 20 years ago with 3 professors. You see them down there. They don't look like that anymore because that was in the early days. They wore lots more hair and they could become white. But basically, this was as a response to an Air Force request. There was a problem that Air Force pilots were having. They were in an aircraft going fast. They were traveling in and out of sun and cloud. And they wear these visors where all the information is digitally displayed in front of head-mounted visors. And all of that information would wash out in the sun. It's like your phone and your laptops wash out. So the information would be lost, and here's a fighter pilot going, possibly towards the sun, and suddenly they don't know what they're doing because they rely on that information a lot. So they approached the Liquid Crystal Institute out of Kent State. Said, hey, we need a solution for this problem. What should we do? And these 3 professors decided they want to come up with a solution. They put in an SBIR. They got a grant. It literally started. That is the first headquarters. That's what it looked like. They put in the first patent. That was like the core patent. They came up with a new technology, and they figured it out. How did they figure it out? They were Liquid Crystal scientists. They said, well, there's a way that you can make a new kind of liquid crystal film where you can switch it electronically, and it can go from clear to dark. And it's very hard to show it pictorially, but maybe the best thing is I have a GIF, and this is actually what it does. It's an eyewear that does that kind of switching at the press of a button. But it took a very, very, very long time to get to here, from the initial, what you saw, the headquarters, and the prototypes that they were able to make. So now when you look at the company website, you see all these nice things. We were able to commercialize that film into an eyewear. We're able to put it both on the consumer end for sports, and also at the moment we've just been approved to sell it to the military because there's still a need for soldiers for exactly the same technology, and so on and so forth. And This is a super complicated slide that I was am reluctant to put up, but I just want to show you the complexity of what we had to deal with. So what we had was a platform technology, a switchable liquid crystal film. It had technologies, yes, in the eyewear, which is where we are, but it also has other applications. You can do it in displays, you can put it in transportation, you can put it in sunroofs. A lot of people would like to have switchable sunroofs. The same architectural windows. Wouldn't it be great to have a window that can go clear to dark just like that, and that you can control that? So this is what the business strategy of the company looks like at a glance. And down the bottom is where the IP comes in. So it's very, very closely tied in. So obviously, as a 30-person company, there's no way we can do all of that. So how are we going to even achieve what that is? Well, some of it we can maybe make, but we do have to make alliances, and we do have to have partners and enter into some agreements. And how are we even going to get to a place where we find these people? Again, small company in Kent, there's got to be some way that you put yourself out there. So that brings us to a discussion of really the close tie between business strategy and IP. And as everyone knows, the business strategy is to manage available resources to achieve the business objectives. And when it comes to IP, you got to ask, well, first question is, what's your business strategy? And then try and figure out how IP fits into that. But IP has a dual role. IP is a resource. I'll go into that in a little bit. But IP also creates value. So it can be a huge engine of value for the business. It's a resource because if you look at what resources you have, say at our company, we have people, we have tangible, equipment, there's money, and the intangible asset, which is the IP, whether it plays a small role or a large role, but it's definitely a resource that we can use and leverage at the company. I'm going to take you back to that big slide that's super complicated, and now I'm going to see how I've just taken the heading from the top and then try to parse it out a little bit and see how IP comes into that. So the first thing we try to do and are continuing to do is to actually make eyewear. It's new eyewear. It's not been there around before. These down here, by the way, those are trademarks, so you can't ask me about those. But that's the name of the actual product that we have, and the name of the company, sister company that sells the IP, that sells the eyewear. But to be able to make that product, you really have to wrap IP around it on various levels. So you got to, when you come up with a business strategy, you got to go to your people and your engineers and your business people and say, well, are we going to make this? Yes. Well, so what does it look like? What are all the bits and pieces like? How can we wrap patent protection around that, trademark protection around that, and really do it at various levels? And I will go into that a little bit more too. But then you also have to partner with some bigger players. And one of the ways to do it is to put patents out there that show your sophistication, that show your expertise in a particular field, so that these people actually come to you. Because if you pick up the phone and call Merck, and you are a small company in Kent, they wouldn't know who you are. But when they see your patents, then that's a different story. Another partner that we found was a Japanese company, so Nippon Printing is a little bit like the 3M of Japan. And the reason they came to us was they were thinking of going into this, putting liquid crystals on plastic, which is what we do, and they came across one of our patents. And they actually told us, they said, we went to our IP lawyer and said, hey, can we design around it? And it was like, no. So they approached us, and we formed a partnership with them. We actually now have a joint venture which just launched for them to be able to make the large area and the things that we cannot make. So that was a success story right there. So it took a very long and tortuous path to get there. And then sometimes you have to then keep thinking about, well, where else can this be used? Maybe we had never thought that, for example, a partner could be Panavision or what they do with their cameras. But when you put enough of a portfolio of patents at some point, it attracts attention. And then if that's an area where they're trying to solve a problem, they're like, hey, maybe these people can help us because this seems to be what they do, and they're good at it. So you create IP portfolio in a business to either create a pull or a push. I'll go into that further too. But it's really integral to what you're trying to do. And frankly, we would not have been able to do any of this if we did not have an IP portfolio. So we know that IP creates value. And my mission here today is to show you how you need to be married to a business strategy. In my case, the marriage is actual. The CEO of the company is my husband. So to go back to when I was at law school, and then, I did patent. I wanted to go into patent law, and I went into practice. And a few years after being in practice, he decided to headhunt me across the dinner table. And, after I had been complaining a lot about what they were doing in the company with the IP, and I was like, well, why don't you come and do it then? As kind of a challenge. And I'm like, well, okay then. And here we are, 10 and a few years later. But really, it needs to be close. There's almost no end to how much we can discuss these things and how much strategy goes into it. But I want to go back to the basics. I know that our company is a little unique for a small company like that. It's very IP heavy. But there's also inventors out there. There are also sole inventors who have ideas. And there's just some ideas that people have about patents that I've come across. And I want to go through that. So I want to change gear from a very technology heavy and possibly savvy company to a little more basic. So what are patent rights? You all know the text. Patent right is the right to exclude others. And that's from making, using, offering for sale, or selling the invention in the U.S., or importing the invention into the U.S. How that translates into people's minds becomes interesting. So, to some people, they think they need a patent to make their product. To some, they think they have a patent, so now they can make their product. And some people think, well, I have a patent, therefore I can stop my competitors from making my product. And everybody's thought all of these. So I need a patent to my product, to make my product. Is this correct? That's not correct. And here's why. It's more than, I really have inventors who have a great idea, very passionate about it, and so inventors. I work here with also the pro bono clinic, that's the access one. So you have inventors, sole inventors, they have an interesting idea and they really want to put a lot of effort into it, and they feel like they need a patent to do it. And I feel like, why? Why do you feel that way? Have you searched to see anyone else has a patent in this area? Can you design around it? Does it have to be, do you have to worry about if somebody else even does have a patent? Do you have to worry about that? For bigger companies or startups, for example, can you approach your competitor? Some people think, well, we can't ever talk to our competitor. No, that's not true. Have you thought about approaching them for a license or for a partnership if you're a small company and they're a big company? And if you need funding, maybe that is not the best use of your resource straight off the bat. Are you going to make your product yourself, or are you going to partner with someone else? So all of these questions come into it. The next interesting one is, I have a patent so I can make my product. And this one blows people's, I'm sure not everybody's, but some people's mind. Maybe yes, maybe no. Why? Why, if you have had an invention and you just patented it, why can't you make your product? Here's why. Here's a piece of prior art. This is another patent or another product out there, and it has elements A, B, C. You have a great idea. Let's call it idea D. You can patent that idea. Your patent will cover, the product will cover A plus B plus C plus D. Can you make that product? Should I actually ask for it? No, because you're going to need still a license to the prior art, which is A plus B plus C. So it is not enough to get a patent to make your product. And the third one, I have a patent so I can stop my competitor from making my product. And I'm going to later on tell you the story of this inventor who came to me with exactly that idea. Sole inventor wanted to stop big bad company from taking his idea and selling it for cheap. This is what you think your patent looks like. It is a big deterrent to other people to make your product. But that's not necessarily true. Many companies will simply ignore your patent and make their infringing product anyway. Why? Because it's really expensive to enforce your patent. And while some people may have the money to sue, many, including our company, does not. So really, this is what your patent is. The paper tiger is really not worth, it's not going to give you the kind of protection that you think. So these are all things to think about when it comes into the economic reasons for getting a patent. So now that we spoke a little bit about how a technology company would think about a sophisticated IP portfolio and how you can even go all the way down to the sole inventor level and what things you should be thinking about. So let's talk a little bit about the intersection of business and IP. Well, of course, one of the questions is what type of IP you like to use. Now, I do apologize here. I'm not going to I can't talk about comprehensively every aspect of IP. There's a lot more. That's why I put ... There's more to it that goes in there. But I do want to emphasize a few things that are close to my heart. They may not be close to yours. I apologize. But here are the forgotten ones that I want to just go and say how valuable they are. You have your provisional patent applications, you have design patents, and you have trade secrets. And I talk about these because they are less money and they can still be very valuable. I have that banner. My daughter was joking today. So every time you have the alpha micron thing, it says, why are we doing this? It's true, but it always has to be the one question you ask yourself. Why are we doing this? Oh, did we miss a slide? What happened here? I'm sorry. No? Oh, some slides are missing. Well, never mind. I will just walk. So what is the important aspect of the provisional patent? It is cheap. You can write it yourself, you can file it yourself, and it's going to cost about $150 to $300 to submit to the patent office. What does it give you? It gives you a year to say patent pending on your product. So you can take a year to take a look and see if your product is viable. And it's secret. Nobody will, if you don't file an actual patent application after 3 years, nobody will know what's there. All the information is there, secret, nobody knows it. It's not going to see the light of day. So what better opportunity to file something cheap, put patent pending on your product, go out there and see if you can get funding, if there's anybody who's interested, and if you decide it's not, then it's secret, nobody will know. And that's what the slide was going to say. The next slide was, but beware that if you do file a provisional application, it needs to look as close to an actual utility application as possible. Really put thought into it. Make it as complete as possible. And drawings. Even your very crude hand-drawn pencil drawing, what that is, can be made beautiful by a draftsman. Put them in. can make it. It does not need to be any more elaborate than that. Maybe I should stop to ask nobody's asking questions. Yes. Yes. So it's the process that we make for making a liquid crystal. It's a roll-to-roll plastic, liquid crystal and plastic process. So what our company did is it's the first really to put liquid crystals on glass. Most liquid crystals are on glass. All liquid crystals are on glass. It's your TV, LCD TV, your computer screen, your phone is glass. Boy, if we could have plastic phone covers, that's great. But it's not, it's glass. So when we did, one of the things that we did to be able to put it on an eyewear was to put it on plastic. So this is a roll-to-roll. There's 2 rolls of plastic, and it's traveling, and you deposit various things, including the liquid crystal, and then you put the upper layer, and then you roll it. So we had to come up with entirely new processing techniques to even make this back. So that's what that is. Did it look familiar? No, you were just wondering what the heck it was. No, that's actually what we use, and that's one of the things that's going to hopefully, that's why it's got the goggle shape, so you can use it from anything small like a goggle to large like a window to make it that. The inventor story is the story of the inventor that I met, and I just want to go through so that he was an inventor. He was actually somebody who was doing woodwork, and he had come up with an idea of how to make, like a dowel machine, how to make a wooden thing, and I don't know what it's called, but it's what converts 33 records into 45. So, yes. Right? So everybody knows what I'm talking about, all those people who actually seen record players, you guys are included. It's, you know, you have the 33 records, RPM records have small hole in the middle, and the 45s have larger. And he was so artistically and also kind of engineering minded that he said, I came up with a beautiful design. I'm doing this with wood, and I think it's great, and I can sell it, but I need a patent because there's a huge company in Pittsburgh, and that's what he does. He goes and sees what has been successful in the market, and then he sends it to China, makes it, sells it for cheaper, and then and he had been laboring over this issue for about 5 years, thinking how to turn this into a patent. Well, we did some patent searches, and they were iffy. It's the best I could put it. We didn't know if you applied for a patent, whether it would actually issue. 50-50 chance. There was some good prior art that could have excluded him. He had all this description, he had all these details going. They gave all the details and the dimensions and how to make his product. And of course, he was the sole inventor. I mean, he didn't have any money. One piece of information was that he belonged to this wood shop, fan club, whatever it's called, where they all were like on this chat, and they all knew about each other, and they all were kind of customers of each other if somebody came up with a new design. So that was an interesting, and I told you about, this was his fear. This was his fear. So he came to me and said, how can I make this into a patent? So after all of that discussion, I thought, well, why do you want to file patent application? Why don't you file, what I said, provisional, you can file it, you go, description and drawing, just go ahead, file it. Think you put patent filing on your product. Do you think all your fans would have bought whatever they want to buy in a year? And it's like, yeah, I think so. So go ahead and make it. And sell it. And by the time the year's done, probably all the people who are going to buy it have bought it. And, you know, you've just saved yourself a lot of money. That's where you should be putting your money. So this stuff really becomes real. And I hope that I can persuade some of you practitioners to tell clients to come to you to really think deeply about what they want to do and why. It's very tempting to say, well, yes, I'll take your work and I'll do it. And as Professor mentioned, in my previous life, I was a dentist, or sorry, but that means I started as a dentist. And I'll tell you this story. So I'm sitting in my surgery one day, and this person comes in and says, I want a gold front. Okay? Look at the front too. Nothing wrong with it. You don't want a gold front as well because I think it looks cool. I was like, well, I am not cutting into that healthy front tooth to put a gold front on. And he was truly mystified. He's like, why not? I'm going to pay you for it. I'm like, I know you are. I'm still not going to do it. I just said, no, there's plenty of it at the door, but I'm not going to do it. And the same, if I have a client that says, I want to do this, and I'll pay you for it, will you do it? If it doesn't make sense, it doesn't make sense. And you just need to talk to them about that.
Sometimes, this is a comment, not a question, people want to get attached for emotional reasons rather than economic reasons.
Many times.
So,
Yes. Absolutely. Absolutely. And there are university professors who want that too, because that gives them recognition in that way. Oh, absolutely.
but that's a career thing, so that is kind of economic.
Yeah, so there's a lot of pieces that go into it, but it's good to have that conversation and for the person to realize why is it that they want to try this. And if they still say, yes, go ahead, it's not as bad as the tooth situation, because that's kind of irreversible. Taking money is not quite as bad, but, as long as they understand that that's what it is, and that the value is not any of these other things that they think is going to happen, which is not going to happen. Design patents. I'm sure you've all heard the big Apple versus Samsung design. Who knows about the big battle between Apple and Samsung? We know, but over the design patent. Yes? Yes? Yes. Yeah. So this was a big deal. And this catapulted design patents into people's consciousness. And here's why. Happened in 2011, that's when the case began. There was a $1 billion verdict in favor of Apple. And Apple Council maintained that Samsung's newfound success was the result of a slavish copying of Apple's world-famous product design. Slavish copying. Great word. Let's see if that happened. This was what Samsung looked like before iPhones came out. iPhone comes out 2007. This is what Samsung looked like after. Do you think it's slavish copying? I don't know. I leave it to you. So a lot of people made a lot of fun of this. This is Stephen Colbert's sketch, which is great. And I hope you can go and YouTube it. But he said, Apple claimed and patented a rectangle with rounded corners. Yeah. So this is what they won. They actually patented that. And people were flabbergasted. And for those who are into design patents, you can read, but it was so clever. So clever. So the front screen vertically centered, black, it's flat. So they showed all of these features, and they had all these different embodiments. And now this was what was so interesting. So usually design patents have multiple embodiments to depict variations in a single claim. And Apple decided they're going to have variations in claim scope by making some lines dashed and some lines solid. So I'm sure you all know, but everything that is solid is what's claimed. Everything that's dashed is not claimed. So they had the same drawings, but they kept switching what was solid, what was dashed. So they claimed just the round button. They claimed the border separately. They claimed that screen that was edge to edge separately. So that they could get somebody with each one of those separately. And for example, on a Samsung, that button is not round, so that does not infringe a button that is round and claim. But it infringed everything else. It infringed the border and the screen and so on. And so on and so forth. This one, I didn't even have to put the picture up for you, but here it is. That's Apple, that's Samsung. I mean, so design patents are again cheaper. They are easier to get through the patent office, and they are a very valid way of enforcing your IP rights. But may I please If you're going to write a design patent, look at Apple first and learn. Just learn what they did, because it's truly education. Last one, trade secrets. They are secret, so these are the attributes. They're cheap. You don't have to file an application or anything. They're just there. And they can last forever, like the Coca-Cola that we all know about and everything else. But what I want to really bring home here is that any decent IP portfolio must have and does have trade secrets. And a lot of times, that's really where your value comes from. Because you can put, like we did in that patent with the roll filling, you can write as much, detail as you want about how a system works, but there's always more know-how that goes into how to operate it and how to make it. And that's where your trade secrets come in. Where strategy comes in for trade secrets is security. There's physical security, there's what you put in your agreements, and I have a little bit about that, which may or may not be useful, but I think it's something to think about. And then there's cybersecurity that's coming up, and that's because of this issue. So not enough to just put locks on your doors. You do need to provide that. And show that you've provided the level of security that is necessary. Yes?
Here's the pros and cons of dealing with the Defense Department early on in the IP processes. Do you find it more restrictive?
Oh, that's a fascinating question, which I would like to come back in a different talk, because it's a huge amount of dealing with due diligence. But like everything else, it has pros and it has cons. Yeah. It's great to partner with the government, because you can become really enforced. If the government's not going to go and buy or going to infringe it,
I'm more curious, does it restrict your, if you view the commercial market with eyeglasses more favorably than dealing with the Air Force? Would that restrict that?
We actually decided that the government is a better customer than the transmission, because it's big, it has a lot of money, and there's a certain amount of you don't have to worry about market. So even though we started, but the strategy was, if we start with the military, they think they really don't want to activity, and that's not a great thing. So the strategy was to create a commercial product that was just successful enough and shows that it worked in the market, to create the pull for the defense to want it. So when you go to the military, you say this is a commercial off-the-shelf product. So the IP is on it. But you can have it, and that would really cut through a lot of the restrictions that we still have. I mean, we still have to go through the testing, 3 years of testing, every minutia and everything, and we couldn't even take a step. Could I take a cup of coffee without them knowing and approving it? But we looked at it.
The foreign governments knocked on your door as well?
There's some NATO there. There's NATO allies there, and then just looking into how all of that ties in. Obviously, given that the U.S. military is using it, there's certain countries that are no-nos. We're not even no. But NATO countries can definitely. Yeah. But that's another whole very fascinating, area that I didn't even put up there. The interface with military and defense, and that would have been a really long talk. Yes.
The gentleman's question, one thing, and I don't know if you got into it, but there's also another protection called SBR data rights.
Yes.
And that allows you to do sole sourcing with the government.
Yes.
Very valuable provision, because it allows you to get robust contracts.
Yes. Yes. So, did you want to repeat that? Or? So the data rights that the government gets, there are 3 categories. There's unlimited data rights, there's limited data rights. Actually, it's for the government purpose, but then I would put SBIR on. So SBIR stands for Small Business Innovation Research. And when you have an SBIR grant, the government says, you own your own IP. You have patents in the field, you own it, you own it for a certain length of time. It used to be 5 years, you know, the new regulations changed that to 20, which is legal. But after that, the government can use it. But during that time, they cannot disclose it to anyone. And they can only use it for themselves. They cannot go to a competitor and have, you know, tell them your data and have them, which is really what you want at the time. You don't want competitors to do it. So that is very valuable. We definitely have SDIR data right. No, so the new, it used to be 5 years every time it was renewed, so 5 years after the last SDIR grant we had. We just changed it, so now it's become 20 years non-renewed. So it's like a length of a patent. Right, right, right. I just wanted to say that if you have NDAs, if you have trade secrets, this is a clause that we put in our NDA, and some companies won't get it, but it's good to have, because you need to show that you are taking care of your trade secrets, and having a clause like this in your NDA does that. I know we're supposed to talk about contracts, but that's about it, the extent of it, because it's another whole big area of what you say. So we specifically call out that if we say something is secret, the length of confidentiality is basically perpetual until they can show that it is not a trade secret. I also wanted to talk a little bit about NDA, because there's some fallacies associated with NDA. So these are just things that I see, so I just want to kind of pull out some interesting areas to talk about. First one is I have an NDA so I can tell them who they are. Anything. Not true. Just because you have an NDA doesn't mean that they're not going to use your data in a malicious way. So be careful, even if you have that pretty clause in your NDA. Second one is I need an NDA to tell them anything. So it's also not true. There are plenty of companies who would much prefer you talk to them without an NDA. And if you have any secrets or IP that you don't want anyone to know, file a provisional patent application, then go talk to them. And there's no problem. And the reason for the second one is that there are a lot of companies that be smooth with people that say, hey, that was my idea, that was my idea in your iPhone, that was my idea of P&G in your product. And so they're done with that. They're like, you come and talk to us, we can take anything. Don't give me an NDA to sign. Any questions with that? No. So just a few things to ask if you're, a lot of people have asked, you know, what do you put in the NDA, and a lot of inventors. So it really depends if you're disclosing or if you're receiving. Then you can think about the duration. Of course, if you are disclosing, the duration should be very, very long. If you're receiving, the duration should be very, very short, so you don't have the burden around your neck. Be careful what's covered. If you have a trade secret, put in that trade secret clause that we just talked about. Is it mutual is the biggest one. I cannot tell you. Anybody here seen an NDA from any of the big companies, Microsoft, Apple, Facebook? They are ridiculously one-sided and terrible. And it's crazy. It's like, whatever you say, we can use it, but you can use ours and all the rest of it. It's really the first rule is to check to see if it's mutual. Make sure that it has non-use as well as confidentiality, even though it's called a confidentiality agreement, and make sure there's a no reverse analysis clause. Any questions? The question there is just for me to stop. Make sure people don't have any more questions. Of course, the law provisions are interesting. Try and put it in your own jurisdiction if you can. But if that doesn't work, there's a couple of tricks we can do. You can say, well, pay company in California. We're okay if you apply California law, but please don't make us travel to California. Make the venue be here. So you cut your costs that way. And sometimes also arbitration, you can go into New York or London arbitration if it's international, so to make it a little more mutual, so you're not in their backyard. So throughout all of formulating what kind of IP, again, why am I here? Why is any kind of IP here? Don't forget why you're requiring it. What is it for? What research do you have? And how do you plan to protect it? A little bit about enforcement. So the average cost of post-grant review, which is where you can go back to the patent office and say, hey, this patent should never have issued, or an IPR inter partes review, again, you can go to the patent office and say this patent should not have issued, is not cheap. And then when you don't even talk to me about what an infringement lawsuit costs, because it's like that. So it's been my reaction for many years, and it's almost like, why are we even getting these patents if we're never able to enforce them? So I do want to bring some alternative strategies to your attention. It's not like I have a patent, my only avenue to enforce it is to take it to court, or take your competitors to court. You can talk to them. Sometimes that works. You can ask them for a license, or if you're in the cross-licensing situation or a joint development, it happens. Because a lot of times, if you have a piece of IP and a competitor that's interested in it, then it means they're interested in it. There might be, you have to put emotion aside, and there might be some opportunity there. Third-party prior art submissions, I'm going to go into that if anybody's interested, we can skip through that. But that's a new provision that the Patent Office came up with, where if you come across a patent application that is not issued and hasn't had a first office action, you can submit prior art that you think is relevant and color how the examiner looks at that patent application and the claims. And that can be pretty powerful. There are firms out there that will finance your litigation if you really have a very good case. There are contingency fee litigation firms. We're right now in the middle of a litigation we just started against a huge giant in the field, and that's how we're doing it. Non-practicing entities can also take your IP and enforce it for you. And anybody know about the new Amazon rules? So Amazon just came out with a new procedure to take down possible infringing products. Would anybody like, I have a whole slide about that. Would you like me to go through it, or should I? Yeah? So this was very interesting. A lot of people obviously have seen copycats and people from China and so forth selling products that are infringing, and it's very frustrating because Amazon is not liable for those third-party products. So after all the complaining that they heard, they decided to come up with their own, and they just unwrapped this new procedure. It's called Utility Patent Neutral Evaluation Procedure. I'm just going to quickly go through what the steps are. So if this process finds that a product is infringing, they will remove it from Amazon, and they will remove the source and copycat. What's the process? The patent owner submits a form and $4,000. You can only do one claim of one patent. I don't want to hear about all the rest. That's all that you can talk about. Within 3 weeks, if the seller doesn't dispute, they're done. The product is removed, and you can put up to 50 potential products on one form, and you can get rid of quite a few. Now, if the seller decides to fight, then they pay $4,000. And Amazon at that point chooses a neutral lawyer. They have the argument go forth, and it's quite fast. The seller responds, the patent owner does a reply, the final evaluation between 14 days, so you can see how fast this can go through. Winner gets their money back, and the other 4,000 goes to the winner. And it's new, so a lot of lawyers, of course, are wringing their hands and like, we're not sure about this. We know of a company in Kent who is using this procedure right now to take some infringing products, so they're really pretty happy with it so far, but we'll see. So just know that this is available, yes.
Question, how do you protect yourself with process from getting the third-party judgment?
based on this. I don't know.
I mean, because essentially you're saying they're infringing, right?
Right.
And a letter now
Right.
is enough to take into court to, you know, once you start talking about the infringement, to get you to court, and then you're on that treadmill of trying to find the expenses to pay for your defense,
Yeah.
that detail.
Yeah. So it's like any other situation where you have to set error, should I write them, should I not, and there's that instructions that we were saying. Just think about it very carefully. Can they use this to file a take action? I don't know. Because just because it's new and it hasn't happened, my initial reaction would be probably yes. Will it be successful? I don't know. But will this be seen as threat of suit? I don't know. But this definitely always. I mean, if you have to think twice about writing them a letter, you definitely have to think twice about doing this, because this is quite a bit more involved.
So who decides if the product is removed?
Amazon. The lawyer decides if it's infringing, tells Amazon, Amazon takes it off.
What's there's and who chooses that? Amazon?
Amazon.
What person in your organization chooses?
Nobody knows, which is why a lot of lawyers are not very happy about it. Yeah. Companies, on the other hand, are happier about it because it's a fast, much cheaper way to get their competitors' products up. Otherwise, you're in for $5 million and a 3 to 5 year process.
Do they sell Samsung?
Amazon? Probably. But why? Do you think Apple's going to use this? I don't think so.
I don't know if Amazon,
True.
if they have this, or I don't know how new this procedure process
Right.
is. If it was during the suit between Apple, then.
No, those suits are always teaching. It's always infringing. Somebody's infringing something else. Great question.
Is
I
the
do.
sole issue in the Amazon process infringement?
Yes, I mean, they have different procedures for trademark and copyright and whatever. That's much faster. But this one is for patent infringement.
Okay, what about an anticipatory prior art that was not going to patent?
No, you cannot do patent validity this way. You cannot attack patent validity. It's just for this product is infringing mine, take it off. Don't sell it anymore. Yeah.
So this is kind of like forcing you out of court and into a arbitration situation.
It's not forcing you because it's you choosing, but you're choosing this over, and I can tell you as a company, a lot of companies are very tempted by this process, over a court process.
I'm just saying this, like,
Cheaper and
I'm
faster.
talking from my day today, talking about, you know, how you have to do arbitration if you want it, you know, if there's a pot of an account, you can opt out of the arbitration, however, you're still going to waive jury trial.
Right.
And it's like, what?
Yeah, but
I mean, the lawyer must have sat, you know, took hours.
Figure it out,
to
yeah.
write this thing.
yeah. No, this does not stop you from, I'm just going to go through these fast. It's not going to stop you from taking that claim and bringing it to court. Because this is not a judicial process.
Well, obviously, you
Right,
know.
right. So you can, if you want to, you can still do that. Or the other. Yes.
Is US based only if
Yes,
they have foreign pilot people?
Well, the procedure is in the U.S. The third parties who sell can be based anywhere in the world. Amazon.
But if you had a foreign patent that they were selling in the US, would they take off the US customers or only
it
after
has
that
to be actually
jurisdiction?
U.S. patent. I mean, that would be, yeah.
So once you like win that, do you then get to bar any other companies coming in? Like, so like basically did like Amazon sign you right, you've shown them that you're passing a ballot. So it's like, what's to stop them from just creating a new version account and like continuing to sell
Right,
it?
so Amazon said they can track if it's the same person goes underground and comes up with a new name. Apparently they will know that and they will not let them do that. Can people find a way around? I don't know, but at the moment they do recognize that that's a problem, so it's like a whack-a-mole, you know, you hit this one and then come back to something else, and I think they're not gonna allow that to happen.
What about literal infringement versus document infringement? Would the Amazon process
gone through it to see how sophisticated that lure is. And right now, we don't even know who the lure is, presumably it's a patent holder, but there's just not enough data on that. Anybody want me to talk about third-party prior art submission, or should I just, in the interest of time? Ooh, nope, I guess I will not be talking about this. So just those three bottom categories, it's all about who comes up with the money. And these are just some thoughts to be used when you come up with how to synthesize a cohesive patent strategy. Just a few examples. This was one of our earlier products. Back to the Alpha Micron story, this was a ski goggle. So that was the idea of one patent is not enough. You have a product, you have to think of all sorts of ways and protections to wrap around it. If you have some core technology patents, you have some other types of patents to do with connections and so on. You do have some trademarks, and there's always some trade secrets associated, so on and so forth with other products. And we're not the only ones who do it. We do not make Gillette. But they're known for wrapping quite a few patents around every single product that they have. So just quickly, there is a pull strategy where first you come up with your business idea. What is your business strategy? The goal of business is to stop. Are you going to exploit this IP in-house, make the product? Or are you going to stop your infringers? Are you going to license it? So the business strategy comes first, and you build your IP around that. And sometimes it's push. So it's kind of nebulous. So it's like, well, if you have put a lot of IP out there, people will come and approach you. I realize that the license and partnership is the same in both, but sometimes you have that as a goal. Sometimes it happens because you just happen to put a lot of IP out there. There are some even, we have patents for bragging rights. That patent that you see out there, continuous wave directional emission, liquid crystal structure and devices and laser, that's not going to be a product during the life of the patent. But that establishes us as people who are very high up in the industry and know what they're talking about. Future products that we never thought of, and sometimes you can cover your competitors' products with your patents. That's kind of what the Alpha Micron patent portfolio looks like. So lots of bits and parts, future products, scientific prestige, and then we have our current products, we have core patents, and then patents that we build around the products. And that's all I have. Yes?
Just I wanted to add that in the Apple, Samsung case, Apple won. And you won huge.
Yes.
Sum of money, but then I went to the Court of Appeals and it said, well, that huge sum of money doesn't really represent the lost profits because the iPhone itself is a very, almost insignificant part of it is the difference in the ship.
Yeah, they definitely reduced that pie quite a lot. Yeah. Yeah. But I think the notion was, at the Federal Court of First Circuit, did not do well with award standards. Our lawyers made this point. They're like, well, they're okay with, reasonable damages. When it's huge, like $1 million, then they really look at the trade secret. And I think that might have played into it.
Yeah. And something else I wanted to bring up is that a lot of lawyers know about the statute of limitations. And, in, say, a negligence case is 2 years, or an intentional tort case with literally lost for 1 year. But in patents, you only have 1 year to bring your invention to the patent office. If somebody can prove you made and used the articles more than a year before you brought it in,
That's right.
then they can make it invalid.
I wouldn't call that a statute of limitations. The true statute of limitations is how long you have to sue your opponent
Right,
for infringement, and that's still.
You got it.
Yeah. Yeah.
But the thing I wanted to bring up is, the other point is that if you file a provisional, then, ordinarily, this is a law, I know it's not a statute of limitations.
A bar, it's a time bar, it's a time bar.
But if you file a provisional patent within that year, and actually what you're giving yourself is 2 years to go to the patent office, because when if you
So,
file a
but you
provisional-
cannot go back to the original provision. That goes. You've lost that.
No, what I'm saying is, you have a year to go to the patent office from your date of invention.
Yes.
And if within that year you file a provisional, then you get another year. You have a patent date.
Oh, I see. So from when you, yes.
So actually, with that, you
Yes.
can get 2 years,
Yes.
and you have a date of filing your patent when you
Yes.
file it.
Yes.
It relates back.
Yes, but that's why I gave the story of the inventor, because he wanted to make his product, and the minute he puts his product out there, then it's published that.
Yeah.
It's not something that he would, yes, he should tinker in his own basement until it's ready to make, then file a provisional with himself.
Yeah.
But if he puts it out there, then that's where it becomes published.
Well, I think we're going to thank Dr. Alabi. And there's a reception outside.
Happy reading.